Straight ahead on Law&Crime Daily. Closing arguments may soon be presented in the Olympian attempted murder trial.
He had a problem with a particular boarder who he wanted to leave the farm, and the person would not leave.
Did Michael identify to you that boarder?
Yes.
And who was it?
Olympian.
Plus, a firm trial date is now set in the deadly Waukesha Christmas parade attack and the Pike County massacre. Why an expert witness in the O.J. Simpson trial testified at a pretrial hearing. But first, could a verdict soon be delivered in the Sarah Lawrence College sex cult trial?
It all stems from one person, according to the government, who they describe as the crime boss.
Among others, authorities allege he exploited several of his daughter Talia's college friends to gain money and power for a decade. His alleged crimes came into the spotlight after a New York Magazine article was published in 2020. The government's key witness, Claudia Jury, painted a grim picture of what she says life was like for her after meeting Ray in 2011. She testified to Ray's alleged physical and mental abuse to gain control over her. Jury told the jury she turned to sex work to pay Ray back after he convinced her she had poisoned him and caused damage to his New York apartment and his father's home in North Carolina. The 31-year-old testified that Ray had taken upwards of $2.5 million she had earned through sex work. Ray's other alleged victims testified, including 3 siblings who shared more about Ray's alleged violence and threats. Ray's defense attorneys have painted him as the victim, claiming the alleged victims tried to kill him and destroyed his property. We've shared some of the evidence the government has presented, which shows just a small glimpse of what went on over the last decade within the Ray family. Law&Crime's Adam Klasfeld is following this trial closely. He was inside the courtroom as closing arguments were presented.
The jury has heard the entire sordid tale. The defense is trying to posit that this is a group of storytellers. They're saying that essentially encouraging jurors, in their words, to go through the looking glass. And it was a constant refrain of the defense summations that they believed these stories, that they believed Larry Ray when Larry Ray told them that he was being persecuted by powerful enemies, that they were poisoning him, that they were all participants in this elaborate tale. That's how the defense wants to view this. But what the government is saying, and what hundreds and thousands of trial exhibits, videos, audio tapes shows, that these were students who suffered, according to the government, extreme physical, sexual, and mental abuse by a man who extorted them for hundreds of thousands and millions of dollars in some cases. So that's a story that the jury is going to have to suss out into more than a dozen serious federal charges that can put Larry Ray away in prison for the rest of his life.
A story indeed. Joining us today is legal analyst Matthew Mangino and co-host Terry Austin. Matthew, what do you think are the strongest points the prosecution made in this trial that came through in closings?
Well, I think they were very effective in painting this as a criminal enterprise, and that Leonard Ray was the patriarch of the Ray family. And they laid out, his ongoing years and years of mental abuse and physical abuse and sexual abuse, and how he controlled and manipulated these college students, friends of his daughter, to go out there and to generate literally millions in profits from sex work, and then to try to launder that money and evade paying taxes on it. And I think the prosecution was very effective in methodically going through that and explaining it to the jury.
Yeah, definitely a very strong government case here. But let's look at the other side. Terry, is there even a single charge you think the defense raised reasonable doubt, or do you think it's guilty across the board?
I think we're going to see guilty across the board on all charges. It was just too significant a case against this man. Listen, during closing arguments today, we heard Mary Bracewell, she's the assistant U.S. attorney. She told the jury, please convict him of all charges. And, those charges are racketeering, conspiracy, forced labor, sex trafficking, obstruction of justice. If anything, maybe the defense could get the obstruction of justice. I didn't see too much evidence as far as that was concerned, but I do think the jury's going to say, listen, you're guilty in every one of these charges.
Yeah, maybe he beats a charge or two, but at the end of the day, any number of these charges can see a severe amount of jail time for Lawrence Ray. Thank you both. An update now on a story we first brought you here on Law&Crime Daily. A second arrest has been made in connection to the deadly Sacramento mass shooting. On Tuesday, police say 27-year-old Smiley Martin was taken into custody. This comes just one day after 26-year-old DeAndre Martin was arrested in connection to the deadly shooting. Officials say 6 people were killed and 12 more injured last Sunday. Investigators say a fight broke out near several popular bars and clubs in California's capital. After that, more than 100 shots were fired. Both suspects now face multiple charges, including assault, possession of an illegal firearm, and possession of a machine gun. In a statement, the Sacramento District Attorney says she expects more suspects to be taken into custody in relation to the shooting spree. Still ahead on Law&Crime Daily, a trial date is set for the Wisconsin man facing nearly 100 charges in connection to the Waukesha Christmas parade attack. But first, we look to Ohio for the latest developments in the Pike County massacre case. Our own Anjanette Levy is live with the newest details from Tuesday's hearing. Welcome back. Shoe prints and blood were the main topic of discussion at the hearing in the Pike County massacre, as new details about the night in 2016 are afoot. Law&Crime's Andrew Levy is here with the details.
Brian, George Wagner's lawyers argued against an expert in shoe impression analysis testifying for the prosecution because the defense says the science simply isn't reliable. William Bodziak offered an opinion to the prosecution that shoe prints found in blood at the crime scenes came from Athletic Works gym shoes sold at Walmart stores. Bodziak started with the FBI in 1970 and has written books about shoe and tire impressions. George Wagner, his brother Jake, and parents Angela and Billy are charged with murdering 8 members of the Roden and Gilly families in April of 2016. Many of those victims were asleep when they were shot. Angela and Jake have pleaded guilty to the murders and agreed to testify against George and Billy. And according to court documents, prosecutors say Angela admitted to buying those Athletic Works gym shoes for her sons to commit the murders. Bodziak says the texture of a shoe would only be identical to one specific shoe mold, meaning he can display this evidence and show it to the jury.
What's great about this evidence is that it's what we call demonstrable. So I can take an enlargement or put it on a screen that's highly detailed of the crime scene impression and of the known shoe and of test impressions I made from that shoe. And I can demonstrate the basis of my findings that helped me reach my conclusion. And I can demonstrate that to a court, a jury, an attorney. And technically they weigh the evidence, but the evidence is demonstrable. And when you have demonstrable evidence, that's a big, big test of its reliability.
In the end, the judge ruled against George Wagner's defense team's request to bar this testimony so that shoe impression evidence and analysis will come in. The jury will get to see it. And there was another interesting fact that we learned recently. This came from a motion that George Wagner's team filed asking to bar the testimony of Jake and Angela Wagner at his trial. They said that Jake Wagner told prosecutors that George only went along that night at the very last minute and didn't fire any shots, didn't kill anybody, but he went along to protect Jake in case their father, Billy, tried to actually murder Jake after the murders were committed. So that was an interesting bit of information we learned. We hadn't heard it before. Brian?
Interesting indeed, and maybe a potential defense down the road. Well, back to help us figure out junk science or not is legal analysts Matthew Mangino and Terry Austin. Terry, what's the Daubert standard used for deciding these hearings, and do you agree that the footprint should come in at trial?
Well, the Daubert standard really came from a Supreme Court case with that name, and it's just simply a hearing to determine whether or not this expert's methodology is valid. And they look at several factors. What they want to find out is, has this been tested? Is it a tested theory? Has it been subject to peer review? What is the error rate? What are the standards of control? And most importantly, they want to make sure that there is widespread acceptance in the community for whatever that methodology is. So clearly, this is what was established today. And so the judge thought, yes, this is a standard that is used, and it was accepted.
All right, so it's coming in. But the question, Matthew, I have is, why bother with this? Doesn't the prosecution have more than enough forensic and witnesses? You even have the person who bought the shoe for one of the defendants testifying. So why the shoe print imprint needed in a case like this?
Well, Brian, when I was a prosecutor, when it came to evidence, too much was never enough. I was going to go and get as much evidence as I could that was relevant and put it before a jury. Trying a case is somewhat like playing in a football game without a scoreboard. You don't know whether to take a knee, or to throw a Hail Mary. So you have to be ready, and you have to have as much information that's relevant at your disposal to present the most effective case that you can.
Absolutely. Now, Anjanette, this isn't the first time that William Boziak has been involved in a high-profile case, is it?
No, not at all, Brian. He's a familiar face in criminal trials, and most famously, most notably, I should say, he testified in the O.J. Simpson trial back in 1995. For those of us who remember that was some time ago, but that was a trial watched by people around the world, and he offered an opinion about those Bruno Magli shoes that O.J. Simpson said he never wore, but he testified about the shoe impressions left in blood in that case, and today he said he actually has testified 500 times, and not always for the state. Sometimes has testified for the defense, and his testimony in some cases has actually led to an accused being exonerated. So that was some interesting information that came from the hearing. Yeah,
not too long ago, Anjanette. I know I was probably like 7 or 8 at the time, but I think we all remember. But thank you, everyone, for the update. Coming up on Law and Crime Daily, we head to New Jersey, where the trial of former Olympian Michael Barisone may soon move to closing arguments. Plus, the deadly Waukesha Christmas parade attack. Welcome back. An October trial date is now locked in for the suspect charged in connection to the deadly Waukesha parade massacre. On Monday, 40-year-old Darrell Brooks appeared in court where defense attorneys motion of last year. Prosecutors say Brooks drove his SUV past the barricades of the annual Waukesha Christmas parade, killing 6 people and injuring dozens of others. Brooks is charged with multiple counts, including homicide, recklessly endangering safety, and use of a dangerous weapon. In the end, Judge Jennifer Darrow denied the motion to delay the jury trial after hearing heartfelt messages from family members of victims and survivors of the parade attack. Jury selection in the Waukesha parade trial is now expected to begin on October 3rd. Legal analyst Matthew Mangino and co-host Terry Austin are back to break down the latest in the coming deadly Waukesha parade trial. Terry, the judge denied the defense's motion to start in 2023, but with all the witnesses and victims, do you actually think the case can start this year? And what discovery would be needed in a case like this?
Well, I think a start date this year is a bit ambitious, but I do think it's reasonable. It started back in November 21st of 21. So this has been almost a year. October certainly would be a year. And I think listening to the victims' family and all of the evidence that they have really made the judge feel as though they needed to start this case and get the evidence in and figure out what was going to happen at the end of the day. Look, we know 6 people are dead, dozens were injured. They're going to be looking at the video. There's lots of video here out in the street. People were taking video. They posted it on social media. We also know that there is video just in the street. So they're going to look at that. They're going to talk to all of the multiple witnesses. It is going to take time, so we'll see what happens. It's ambitious, but I think it can be done.
Yeah, just to give our viewers some context, like a one victim homicide in Brooklyn may take about 1.5 years, 2 years to get tried, so this is quick. Matthew, change of venue will likely be argued all the way up to the day of the trial. How could venue change jury selection here?
Well, you're correct. I mean, the change of venue issue can go right up to when you're already looking at and talking with the jury pool, because the question in change of venue is not whether you've heard about this case, and certainly everybody is in that area is going to have heard about this case. But whether or not, based on what you've heard, you can continue to be fair and impartial. So that issue of change of venue can be revisited over and over again as you're trying to get a jury seated for this case.
Yeah, it's going to be difficult. I don't know what part of Wisconsin we're going to find ourselves in this case, but best believe it's going to go to trial at some point in time. And closing arguments are moved to Wednesday in the trial of ex-ICU doctor William Hussell. Hussell is accused of murdering 14 patients while practicing medicine as an ICU doctor at Mount Carmel St. Anne's Hospital in Columbus, Ohio. Prosecutors say Hussell gave deadly amounts of fentanyl to multiple patients, resulting in their murders. Defense attorneys countered, saying Hussell was providing end-of-life care. Both sides are expected to present closing arguments on Wednesday. Make sure to watch the Law&Crime Network for live gavel-to-gavel coverage and up-to-the-minute developments in the case. When we come back, the defense begins its case in the Olympian attempted murder trial. Could closing arguments soon be presented? Welcome back to Law&Crime Daily. We head now to New Jersey, where we could soon expect closing arguments as the defense moves quickly through its list of witnesses in the trial of Michael Barisone, a man well known to the sport of dressage, accused of attempted murder. Barisone is charged with 2 counts of attempted murder after shooting Lauren Canarak in the chest twice and shooting at her then-boyfriend Robert Goodwin in 2019. The dispute followed a string of back-and-forth arguments about Canarak and Goodwin's living arrangement on Barisone's farm. At the time of the shooting, the two were living in an apartment on Barisone's property while he trained Canarak in dressage horseback riding. In a string of several 911 calls days leading up to the shooting, Barisone said he tried to evict Canarak and Goodwin. Canarak in turn told dispatchers she was being harassed. Barisone's defense team argued he feared for his life at the time of the shooting and suffered from mental health issues. On Tuesday, the defense called 10 witnesses before noon. Several of them were Barisone's former dressage trainees. Barisone's former attorney testified, telling jurors about the change he saw in his client leading up to the shooting.
Did you notice changes in his affect as it got closer to the date of the incident?
Absolutely.
What were your observations?
He became very, very upset, almost to the point of being unable to function. As an attorney, and this was my client, it got so bad I couldn't even have a conversation with him. He was in constant fear of so many things, and all he would talk about, he was in a loop. All he would do was talk about the fears that he had. And here I am trying to be a lawyer to a situation and proposing solutions or possible paths to take, and he wouldn't deal with them. I don't think I realized at the time, how out of it he was. And it only perhaps was later as we got really close to the 6th and 7th when he became just, non-functioning.
Did the fears relate to Lauren Canarak?
No, totally to Lauren Canarak.
Matthew, the defense attorney's testimony was interesting to me. Hear me out, because if a client has gone to a point where you can't represent them, like we've seen in the Vallow Daybell cases, then typically you withdraw from representing them. But that didn't happen. So what does that say about Barisone's mental health?
Well, I mean, you could interpret it in that way that his lawyer didn't go to the extent of withdrawing, from the civil case. Now, this was his private attorney who was helping him with evictions, not his criminal defense attorney. And there's no issue here with regard to confidentiality because obviously Michael Barisone waived his confidentiality to permit his lawyer to testify about these things. Obviously, it's consistent with everything else we've heard from witnesses on behalf of the defense that he was distraught, that he was catatonic, that he wasn't able to function. And so I think it's important testimony as they build their defense here.
Absolutely. Now, Terry, defense counsel has asked multiple witnesses about Barisone's mental state right before the crime. Do you think that will be enough to establish mental health illness as a defense?
I think it might be, Brian, just because the defense counsel asked almost every witness that got on the stand, whether it was the lawyer that we just saw, whether it was someone who was fixing the shoes of the horses. He asked everyone, did you notice a change in Michael Barisone's his demeanor? And most of them said, yes, he was extremely distraught. he didn't understand what was going on. And so what he's going to have to show is, by a preponderance of the evidence in New Jersey, this is an affirmative defense, he's got to show that there was mental illness. And so what he needs to do is to make sure he's asking these questions the way the charge is going to go to the jury. And I think so far he's done a very good job of doing exactly that.
Yeah, it's going to be an interesting and difficult case. We'll see how it continues. But thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.